Good afternoon, everyone. I'm Dolores Sturdivant, and I am a volunteer with AARP Michigan and a retired financial executive. I am so glad you're here with us for Money Matters, Ask the Expert, our virtual series dedicated to helping you take charge of your financial future. This event is our four-part series, and today's topic might just be the most thought-provoking one yet: planning your money's afterlife. It's not always the easiest topic to bring up, but at its core, this is about something deeply meaningful. What happens to your money, your assets, your legacy after you're gone? Over the last couple of sessions, we've tackled some big financial questions: how to make sure you don't outlive your money in retirement, how to protect yourself from scams. You can watch these series anytime on demand by using the link in the chat. But today is about thinking ahead, not just for your own peace of mind, but for your loved ones, your values, and the legacy you want to leave behind. And the truth is, while most people intend to leave something behind, whether it's for a family or a cause, grandchildren's future, many never quite get around to making a plan. AARP research shows that only about 16% of people over 50 have talked with their children about inheritance or estate planning. And shockingly, fewer than half of all US adults have a will. Even among those over 65, a significant number still don't have anything formal in place. So let's just take a quick pulse check. If you feel comfortable, let us know in the chat. Do you currently have a plan in place, like a will or a trust? Thank you for sharing, and no worries if the answer is not yet. That's exactly why we're here today. Because when no plan is in place, families can be left to navigate some big issues like legal battles, probate delays that shrink the estate, and emotional strain that can lead to family conflict. These especially impact women who are more likely to outlive their spouses and may face complicated financial decisions without preparation or support. So, yes, planning your money after life is crucial, but it's also an opportunity to get creative, to make charitable donations, help your grandchildren get ahead, or pass along not just wealth, but your values. And to help guide us through this important conversation, we are thrilled to welcome Henry Guzzo, a seasoned tax and financial advisor with Blumberg and Ameriprise Financial Services. Henry brings over 25 years of experience in tax planning, retirement, wealth preservation, and most relevant for today, intergenerational planning. He's taught financial strategies across the country at universities, hospitals, and conferences, and we're incredibly lucky to have him with us today. Henry's going to start by sharing practical and creative ways you can plan for your financial legacy. Then we'll open the door for your questions. So don't be shy. This is an interactive session. We reserve the majority of our time today for your questions. So if something sparks your interest or you have a question, drop it in the chat at any time, and we'll do our best to get as many of your questions answered as possible. And with that, it is my pleasure to turn things over to Henry. Henry, take it away.
Thank you, Dolores. I do very much appreciate the remarks and the excellent job with the introduction. Appreciate everybody taking some time today and everyone attending. As Dolores mentioned, the topic of today's webinar, planning your money's afterlife. It's very important to all of us here, important to the AARP, and important to me and my whole team. This is what I spend the vast majority of my time doing, and my team spends the vast majority of their time doing, is helping clients make the best possible decisions for the life of their assets and the afterlife of their assets, and being aware of that impact to beneficiaries. So let me start with some perspective. in my very nearly 30 years of providing comprehensive tax and financial guidance across the clients we serve in over 45 states, there are far more questions today that will be generated and offered up than we can possibly answer. And as you can imagine, I've seen it all when it comes to things that have occurred over time. I don't believe we're going to get to every single one, but I don't think that's why people are here anyway, is to get every question answered, but more to identify what are the areas of the situation that need some attention as it relates to what happens if something happens. So we're going to get the main questions answered and then really set out for how do we go about getting the other ones addressed as we need to. Should you have more questions that aren't addressed by the dialogue we have today, or we didn't have time to specifically address your individual question, our website has a substantial amount of information and resources for you at blumarktax.com, BLUMARK tax.com, specifically in the Learning Center and webinar areas. So beginning with the afterlife of your money, that implies it's currently alive, meaning you're currently actively meeting with those trusted professionals and resources to craft your estate plan, your income tax plan, and building or altering your retirement income plan. Questions or ideas raised here should be directly pointed to those professionals you meet with to seek your particular answers. Keeping in mind, things change over time, they evolve, you move over time. These generate ideas and questions and concerns that need specific time to be addressed. So when we think about your money's afterlife, let's paint a bit of a picture. What is the old adage? From shirt sleeves to shirt sleeves in 3 generations. As is often the case, there's usually a significant amount of truth in these sayings. Why is it true? Well, as Dolores just stated, less than 50% of Americans have a will. The statistics I have say even further, 1/3 of all beneficiaries inheriting assets have a negative savings 2 years after inheriting the assets, and 70% of inheritances are spent before that 2-year period is up. Further, 2/3 of American adults die intestate. That means having no valid estate plan, which means the state you live in has an estate plan for you. So that means for most of the beneficiaries the attendees of this session have, the assets they'll receive will go towards the immediate expense in front of the beneficiary, paying off a debt, a home improvement, a to-do list that just hasn't been done, or be spent within 2 years on the next item that comes on that list. And most of them will have to go through probate court to inherit those assets. I realize that's not what most of you want to hear, what your intention is. Those are the facts. So what can we do if we know that? Well, first thing you can do is you can develop a trust. Think of a trust like a bucket. Everything you own goes into that trust, your home, your savings accounts, your investments. When you pass away, you name a successor trustee. The trustee is the person assigned to help distribute those assets to the beneficiaries you elect. The trustee and the beneficiary don't need to be the same person. Many times they're not. Further, a trust can be designed to protect beneficiaries. What do you mean, Henry? Well, that's a good question. Protecting a beneficiary could mean, look, I know you have these assets, they're now for you, but you can only have them at specified times or specified events. So for example, if you're leaving a substantial amount of money, you might say, I'm going to allow my heirs or beneficiaries to inherit some immediately upon my death, some in 5 years, some in 5 years after that, etc. Minors aren't allowed to inherit assets. So you can hold money in trust for a minor for their use when they become an adult, but they can have access to it for any health-related expense or education or anything to support their current living. So a trust by design avoids probate. It doesn't require the court to administer that distribution, and allows you as the person leaving assets to your beneficiaries to control not only distribution, but the reasons for distributing them. A trust is a great tool or product to use to transfer a home, life insurance proceeds, certain types of investments. We call them non-qualified investments, which means it's not an IRA, a Roth, or a 401k. Think of a brokerage account or an investment account that would be held within that trust. It's a great tool to use to pass those assets out. Again, it also protects your heirs from issues they may have, meaning if your child is going through a divorce, the assets are held in trust for your children, not their spouse. If your child is involved in a lawsuit, maybe a bankruptcy, those assets within the trust are not claimable against the trust because the trust is there for the benefit of your heir, not for the benefit of their creditors. So it's an excellent tool to use to pass assets along, to protect them, and to give every opportunity to extend the life of that asset, knowing the facts that we know. Now, it is not typically a great tool to transfer assets that we call qualified. So when I say qualified, think of an IRA, a 401k, a 403b, or a Roth IRA, things like that have a tax qualified treatment where you put money into those assets and into those investments or into those types of accounts, and you got a special tax treatment for that. I'll touch on that here in a moment. Okay. The other thing to keep in mind, a trust is not a will. A will is specifically a set of instructions for the probate court to follow. A will does not avoid probate. It goes through probate, is administered by probate. And a will is also the only document in most states that declares guardianship for minor children. So typically, if you're developing a trust, you'll also have a will to say, here is my distribution plan for any asset not owned by the trust, but also how to declare guardianship. Now, when we talk about qualified dollars, so IRAs, Roth IRAs, 401ks, those pass by what's called beneficiary designation. So declaring who your beneficiaries are on those accounts will avoid probate and allow them to receive those assets immediately upon your passing. I'll talk about in a minute here some of the tax impact of that, but those are the two documents most folks don't have in place, which is a trust and a will, and the two documents that give you the most control over what happens. So a trust in and of itself allows you to name beneficiaries and create a distribution plan and protects those assets from the beneficiary, any claims they have. So let's talk a little bit more about some issues or concerns with trusts. One common question I get is, does a trust protect me from a lawsuit or long-term care or nursing home expenses? Typically, it does not. If it's your trust and you can access it, so can claims against you. It does protect your heirs, though. I'm going to leave some time for specific individual questions, but that would be the first thing I would suggest folks take a look at for their individual questions and situations is a will and a trust to specify what your wishes are at your passing. The second area that would cause a shorter afterlife of your investments is income tax. So I do wish I could see some faces when I ask the question of who here believes over time in the next 10, 20, 30 years, tax rates are going to go up, stay the same, or go down. Most every time I ask the question, it's a resounding, they're going up. Now, I know we just had this one big, beautiful bill pass on the 4th of July weekend, which extended current tax rates for at least another 4 years. Most folks believe over the long haul, tax rates are going up to cover this growing federal deficit. Makes sense. Well, how does that relate to the life or my afterlife of assets? Well, let's talk about those qualified dollars, those things that are IRAs or Roth, or excuse me, IRAs or 401ks or 403bs. Well, for the vast majority of folks here on this call, those are investments or tools currently being used for your current income and lifestyle. When they pass to your heirs, they've got some new rules. The first rule is they must continue to make required distributions from those every single year after they inherit them. Most folks believe tax rates are going up. And third, they must have those assets distributed by the end of a 10-year window. So the very nature that it's now a 10-year distribution plan in a higher tax rate environment, when they're more than likely still working and the assets have grown, just means the IRS is now a bigger beneficiary of those accounts than you intended, and in some cases, an equal beneficiary of your heirs because of income tax. So what can we do to do that? First and foremost, educate your heirs, talk to them, make sure they know, hey, you're a beneficiary of my accounts. Get your financial house in order type of conversation. The second is I would encourage everybody to start thinking about their current situation. What income tax bracket are you in? What income do you need? And does it make sense for you to take additional income out of those accounts and perhaps put it in a Roth IRA where it is non-taxable in the future? That will allow you to pay tax at current, known, and very likely lower tax rates than in the future. So that is a tool we use all the time to help people understand what tax bracket are they in, and does it make sense to get those dollars into tax vehicles that are tax-free. And again, most people do not know that when they inherit assets, they have to have those distributed within a 10-year time frame for anything that came out of an IRA, a 401k, a 403b, or a Roth. I would also like to talk about some other ideas that can be impactful, especially given the new tax code that has passed very recently. And those would be things like what's called a QCD, a qualified charitable deduction. Many of you are taking what's called an RMD. The IRS loves acronyms. An RMD is that required minimum distribution you must take out of your IRAs every single year once you reached what used to be 70 and a half, which is now 72, moving to 73. Every year you have to take a minimum amount out of all of those accounts. A lot of folks don't know that you can take that required minimum distribution up to a limit of about $100,000 per year and go directly from the account to a charity of your choice. It satisfies your requirement for a minimum distribution and is also non-taxable. It doesn't show up on your tax return as a taxable distribution. That's a huge opportunity for folks to extend the life of their assets because they get to support the charities they're likely already concerned with and contributing to, satisfy required distributions, and avoid federal and state tax on those distributions. As the tax laws have just recently changed, that's going to become more and more a beneficial impact to folks year over year. Finally, Dolores mentioned you can have charitable um, bequests while you're alive as an opportunity to extend the life of your assets. There are strategies called a donor advised fund where you can set aside dollars that you have currently, make a lump sum contribution to an account, all of it qualifying for a charitable deduction today. And then you get to control that account and distributions from the account to charity annually. Well, how does that help? Well, what it will do is in the year of contribution, give you a much higher charitable deduction, so decreasing taxes today, but it creates an account where you can share your wishes with your heirs. Share with them the types of charities or organizations you are most concerned about. Promote behavior you believe is important for them to continue, but also maybe list them as the successor donor to that account so that if they have charities that are important to them, they can then continue contributions in your honor. So those would be some ideas and tips and tricks, if you will, to extend the life of assets. So I know I've covered a lot. Again, these are topics very important to us and our firm. These are some of the higher level and most important pieces our clients across the country tell us we should continue to share with others. But I want to open it up, and my understanding is Dolores is going to help us find some questions from the audience of specifics. But I hope that kind of helped frame the issue for everybody in our conversation today.
Thank you, Henry. That was very good information. Let's get some audience questions. I know there's a lot of them. I want to remind everyone to put your questions into the chat, and we'll do our best to get all of them answered. So here's the first question. Melva asked, can I move all money from 401k to Roth?
Good question. The answer to that is yes, you can. Typically, it would go from 401k to IRA, which is a non-taxable event, then from IRA to Roth. You are allowed, there's no restriction on the amount of money that can be converted from an IRA to a Roth in any year. Okay, it's not a contribution limit, so you can convert as much as you want. You can convert $1 million. The only issue is it's taxable on the year of conversion. So Melva, yes, you can. Just every dollar you move from 401k to Roth would be taxable in that year. The reason I say it should always go 401k to IRA is 401ks have mandated and forced withholdings. They don't allow you to choose how much you want withheld from that conversion. So it can be tricky and oftentimes result in taxes owed or big refunds that you didn't desire. When it's IRA to Roth IRA, you control withholding and tax impact. But yes, you're free to move all of the assets.
Okay, thank you, Melva. Our next question is from Burl. He wants to know, to keep my grandkids from spending their inheritance too quickly, are there non-transferable, non-sellable annuities to monitor their spending?
Well, good question, Burl. Let's just run right to the weeds and get a very, very specific question, right? You hit the nail on the head, Burl. That's absolutely an option. Annuities, by design, have either a general beneficiary treatment where they get to elect how they receive assets, or some annuities will provide for a predetermined payout where you control as the owner prior to your passing, here's how you must take an investment. That is absolutely allowable. There's a catch, though. There's always a catch. If it's an IRA, okay, it must still comply with that 10-year window of distribution. Okay, you can't have it extend longer than that, or you'll run into problems. Okay, but yes, predetermined death benefits are absolutely allowed. I would encourage you to talk to a professional in that sense to make sure that you don't end up where you don't want to be, type of thing.
Thank you. Okay, our next question is from Michael. and I think you may have addressed this, but his question is how to pass my IRA and savings to children without having them pay inheritance tax.
So inheritance tax is different than income tax. So right now, the inheritance tax limit is $15 million per person for that estate. So if your estate is above 15 million general terms, you have estate tax or inheritance tax. If it's below that number, there's no inheritance tax. Income tax is always a factor in the type of assets that are distributed. So can we avoid inheritance tax? Yes, if your estate's below 15 million. Can we avoid income tax? No.
Okay, thank you. Steve asked, with 3 years before I knew to take a RMD, should I withdraw some funds from my 401k and 457 now and put them in a Roth IRA?
Steve, that's a really good question. I think that's at the heart of what I was talking about of extending the life of your assets. That would extend it both for you and very likely for your heirs. It depends on what tax bracket you're currently in, how much tax can you afford to pay, and then trying to look down the road when you're going to need those assets in retirement, knowing I can pull them from a Roth tax-free versus from a 401k or 457 and or IRA and pay tax. Keep in mind in 401ks and 457s, you do have to have access to those plans. So if you're still working at that institution or business, some of those do not allow for what's referred to as an in-service withdrawal. You'd have to check with the specific plan. But yeah, if you can afford the tax and you can wait a period of time to withdraw from the Roth, that would be a highly advisable strategy. Make sure to get with your tax professional to know what the specific tax impact of that transaction looks like.
Okay. Dale asks, what is the advantage of a trust over a will?
So a trust allows you to name specific beneficiaries, to control distributions. So you can say, for example, I'm going to leave, let's just say $1 million to my heirs, but you can only have a certain amount at my passing, and then you get a certain amount every period of time, every 5 years, 6 years, 7 years, whatever it is, you predetermine that. That protects beneficiaries from themselves, but it's really your wishes you want to have happen. A will does not allow you to do that. A will just says, here's who my heirs are. Whatever's in my estate, they get.
Okay.
A trust also has beneficiary protection. So like I mentioned, if one of your children goes through a divorce, their spouse has no claim on the trust. If one of your children is sued for whatever reason, that lawsuit has no claim on the trust.
Okay, and Michelle asks, can you list your trust as a beneficiary of an IRA?
You can. There are typically some problems with that. The first is a trust needs to be what we refer to as see-through. You must be able to see through the trust to the individual beneficiaries. They have to be what's called a natural person. A non-natural person would be a charity or a bequest to an organization. If anywhere in your trust you list a non-natural person, a charity, it will not be see-through, which means you don't qualify for that 10-year window of time. So typically, in general, we say things like a trust should be for non-qualified assets, the home, the savings accounts, the investments. IRAs and Roths should list individuals so we don't mess up that distribution and cause a taxable event when we don't desire to have one. Now, again, those are very specific and general, I should say they're very general rules. Specifics can alter that. That would be something you would ask your individual professional.
Okay. Michael asks, is long-term care insurance a good item to purchase?
I absolutely believe it is a good thing to purchase. If we were to say what is the number one expense retirees have? Yeah, I could ask the AARP, and they're always going to say the same thing: healthcare. Well, what's the number one healthcare expense? Long-term care. So we know that if there's any event that's going to derail a successful retirement, it's long-term care. Is long-term care a good thing to purchase? Absolutely. A couple things to keep in mind. When I first started in this business 30 years ago, and Dolores and I in the green screen beforehand were sharing some stories of the journeys we've all had. Many, many years ago, there were over 100 companies that offered long-term care. We're down to less than 5. So we don't have the volume of companies offering coverage. Premiums for long-term care have skyrocketed over the last decade. So what we typically suggest is finding a mechanism to do it that's affordable and then plan for premium increases in the future. But if it's affordable and it's a big concern for you, I absolutely believe it's something that should be addressed. I would suggest working with the appropriate professional to determine which type of long-term care is most beneficial.
Okay, we have a question from Lori. Is a trustee a fiduciary, and what does fiduciary mean?
So it depends on the state you're in, but trustees are held to what is called a fiduciary standard at times, which means they must act for the benefit of the beneficiaries of that trust as their primary objective. So fiduciary simply means that you're acting with the client's best interest or the beneficiary's best interest at heart. So as an example, I'm a CFP. I am held to a fiduciary, a much higher standard than just a general practitioner. So putting the interest of others ahead of your own. Are all trustees held to that standard? Depends on the state you're in.
Next question is from Michael. Should trust be updated to include changes to tax laws, and how often?
Trusts typically aren't guided by tax law, they're guided by distribution. So if tax laws change such that maybe our distribution plan now needs to be compressed, I would say yes. Maybe, Michael, a better way of asking that question, or another way of asking that question, would be, how often should I update my trust? Well, as I said at the beginning, life evolves, life changes, desires change. Your children, your heirs, their situations will change. Maybe one of your heirs is wildly successful and another is not. I would recommend dusting off the trust every 5 years, going back to the professional that drafted it or a new professional you have a relationship with, and have them spell out exactly what your trust says, and is that still fit what you want to have happen? Keeping in mind also, Michael, that your situation may change. Maybe you haven't spent the money in retirement as you thought you would 5 years ago, and now your estate or the value of your assets is much higher. That can have a tendency to change your distribution plan.
Amy states, me and my husband are both retired. Can we still move money from an IRA to a Roth?
Absolutely. A Roth conversion or conversion from IRA to Roth can be done at any time, at any age. Amy, you are not allowed to contribute to a Roth IRA unless you have earned income. So unless you have a job, so to speak, self-employed or W-2. But anybody can convert from IRA to Roth IRA at any time, in any amount. You just have to pay tax on how much is moved from IRA to Roth in the year in which you do it.
Thank you. Patricia wants to know, does the 10-year IRA RMDA apply to older adults? I thought there was a qualifier about it.
Does apply to all IRA owners. So once you make that age, which again used to be 70 and a half, It is now 72 and moving to 73. Once you hit that age, you are required to take a minimum amount out of your IRAs every single year. You don't have to take it out of every IRA. As long as you pull from one that satisfies the distribution on all, you meet the criteria. But yes, it does. Once you hit RMD age, you're required to do that.
Okay. Keith asked if two beneficiaries, do they have to withdraw equally within the 10-year window?
Nope, their RMDs are going to be based on their age, but both of them must be completed with their distribution by the end of that 10-year period.
Thank you. Michelle wants you to discuss annuity and if the beneficiary gets taxed on the R&B, very required to take out if I have already started taking distributions.
Okay, so an annuity is a vehicle by design which liquidates an asset. So the best way to understand an annuity is to understand life insurance as an example. You pay a small premium to have a big death benefit. Okay? We all understand that, I think. An annuity is the same calculation, it just works in the opposite. You give the insurance company the asset and they promise to make a payment out over a specified period of time. It could be a 10-year period, it could be 5 years, it could be your life expectancy or yours life expectancy and a specified period. If the beneficiary inherits that in a lump sum form, okay, so they get a check from that annuity, they will pay tax on the difference between the basis, what you put in, and the growth. So if you put in 50,000 and it grew to 75,000, your beneficiary inherits 75, they pay tax on 25,000. If you're collecting a payment, Michelle, every single month or year, and that payment extends to your beneficiary for that specified period of time, they will pay tax the same as you paid that tax on that receipt of that income. So it depends on what the cost basis or what the tax liability of that annuity is, and then what the payout designation is on that.
Okay. Roger has a question. Does Roth IRA also have to be distributed within 10 years of passing?
It does. It has to be distributed by the end of the 10th year. So, Roger, those distributions will be tax-free to your heirs. So we typically recommend taking the smallest possible amount for the beneficiaries, letting as much of it continue to grow and build tax-free. But by the end of the 10th year, that must be distributed.
Okay. His next question is, can RMD monies be reinvested in any way?
They sure can. It just cannot be reinvested in an IRA or a Roth IRA. So remember, Roth IRAs have no RMD for you, Roger, while you're alive. You're not required to make a distribution. IRAs have an RMD. They have a required distribution. You must take those funds out, but there's no restriction on what you do with it after it's out of an IRA. You could reinvest it in the exact same type of investment, just in a what we call an after-tax account, an individually owned or jointly owned account. You could send it to a charity. You could buy a CD. You could gift it. Once it's out of the IRA, you're free to reinvest as you decide or spend it. It just cannot be done within an IRA.
Okay, Annie wants to know, is a trust the same as a durable POA?
A trust is not the same as a durable POA. A durable POA, or a durable power of attorney, there's typically two people would have. One is a financial power of attorney, the other is a medical power of attorney. Those documents expire when you expire. When you pass away, they're no longer valid. They are the set of instructions for the financial decisions to make if you're incapacitated, and the healthcare decisions if you're incapacitated. They are the documents where you appoint the person to make those decisions if you're not able to do so. keeping in mind in many states, incapacity doesn't mean you're unconscious in a hospital. It just might mean you're traveling out of state or out of the country, but now a financial or healthcare decision needs to be made. Who's making that? So
Okay,
that's what a power of attorney is.
this next one, if I mispronounce your name, I apologize. Sharuk wants to know, is it better to include the house in a trust?
Good question. And again, Sharuk, if I mispronounce it, I apologize as well. Typically, people want their home in a trust because they want it to pass to their beneficiaries outside of probate. When owned by a trust, it's absolutely a much more efficient and quicker transfer of asset from yourself to your heirs. It still also qualifies for a full step up in basis as well, so there's no taxable event when that happens.
Okay.
I don't know
Adrian.
what the record for questions and answers is, Dolores, but I think we're kind of doing it. This is like the $64,000 pyramid.
I know, but I think you're doing a great job. Adrian asked, if a trust has a pour over clause, is a will still needed? If a trust has a pour over clause, is a will still needed?
So a trust will not have a pour over clause. A will. A will or a pour over will simply means, hey, if I forgot to list something and put it in my trust, a pour over will tells the probate court, hey, I have a trust. This asset was missed. Pour it over into my trust. A trust wouldn't have that. A trust wouldn't say, oh, I want to pour it over from a trust somewhere else. No, we want it to all go in the trust. So a will has a pour over clause. A trust typically would not.
Okay.
I should mention also, so in these statistics, it is important if you develop a trust and create one that you fund it. So the previous question about should a home go in a trust, over 50% of trusts that are created are unfunded, which means they're empty documents. So if you go to the trouble of developing and building a trust, put the stuff in there. So that is an important component so that we don't rely on the probate court, whom we're trying to avoid to decrease costs, to go fund the trust.
Okay, Henry, we have some questions that were presented to AARP, and I'm going to give you a couple of those before we wrap up. So one of the questions is, how can I minimize taxes for my heirs? How can I leave money to a cause or nonprofit I care about?
Yeah, so how can I minimize taxes to my heirs? The number one important piece to consider there is the very nature of a trust. So by executing a trust, what you're doing is keeping all the ancillary costs down. So avoiding probate, trying to keep attorneys out of the distribution. Minimizing taxes specifically would be the IRA to Roth conversation we've had today. That's an excellent way of minimizing taxes to heirs because you're paying the tax now versus waiting to pay them tomorrow when they're likely higher. The second way of doing tax minimization would be donor advised funds or qualified charitable distributions. What actions can you take while alive to position those assets into tax advantaged accounts today so that taxes are not due tomorrow?
Okay. What happens if I die without a will?
So if I die without a will, it's what's called dying intestate, which means states have already predetermined what distribution rules will be. So as an example, a common intestate distribution would be a portion of the assets go up to your parents and a portion go across to your spouse and a portion go down to your heirs. So dying intestate is often a expensive route to go because assets end up going where the decedent, the person that passed away, desired them not to go.
Next question. What if I want to leave more money to one child than the other?
That is a very, very, very common question. I would suggest in that scenario, that's the exact reason people tend to veer toward a trust, because a trust will be able to control percentages and say, look, my one child is highly successful. I'm not going to leave him or her that much. I want to distribute it elsewhere. Or maybe you have a special needs situation where one of your children isn't self sufficient for whatever reason, and you want to set up distribution plans to protect him or her. So, in that event, yes, you need to take a look at specific estate planning tools. So, it looks like we have getting cued here that we've reached our time.
Okay. Okay. Well, Henry, thank you so much. As mentioned earlier, this event is part of our quarterly Ask the Financial Expert series, which wraps up with our final event on October 17th, when we'll be joined by someone from Social Security Administration and how to get the most out of Social Security that you earn. The registration link is in the chat. You can also go back and watch our previous events, including this one. These events are free and all on demand. So we thank you for your questions. We thank you, Henry, for your expert presentation. And thank you all for coming. And we hope to see you at our next event. Have a good
Thank you all.
evening.